All right, I'm going to try this again. When was the last time you had something to drink?
Something to drink this morning. Coffee.
Any alcohol.
Oh, that's funny.
Hopefully everyone can have that from here. State your name, please.
Manuel Ramirez.
Thank you.
We are here for a pretrial and there's also a bond violation.
Yes.
The
Cool.
reason being because he did not go to community corrections as ordered after his arraignment. I did speak with him about it and he stated that he was confused. He didn't realize he needed to go. He said that he was trying to pay attention to what Your Honor was saying, but he was nervous. He heard the last thing that came out of your mouth, which was the next court date, and that's kind of all he remembered as his arraignment was finished. We did speak about the warrant. He did fill in the warrant recall. He did not put himself in because he's in school. He's at Washington Community College. But he is here. He does want to address the warrant today. He is willing to go test right now. And he believes he could come back clean. And he's asking for warrant to be recalled and another referral to be made to community corrections so he can get back.
This clip shows a defendant in court for a pretrial hearing and a bond violation. The lawyer explains that the man failed to report to community corrections after his arraignment because he was confused and nervous. He only remembered the next court date and didn't understand the full instructions. The judge gives him another chance by canceling the warrant, but orders him to immediately report to community corrections and be placed on a monitoring device, scram tether. This moment highlights how nervousness and misunderstanding can lead to serious legal trouble.
Cancel the bench warrant that's out or reinstate previous bond. Defendants to report before he leaves this facility to community corrections for placement on a scram tether this time. So we don't have an issue. All right. And then I'll adjourn this out. How much time did you need?
I think the 18th should be okay, Your Honor.
I'll adjourn this to September 18th, 2024, 9 a.m. You understand that, sir?
Yes.
You need to get over to community correction. All right. Thank you.
Consider it G as alternate. The election is 2.206.
Sir, if I give you a test that's going to detect alcohol, whether or not you consumed alcohol recently, are you going to pass that test?
I'm pretty sure.
Why aren't you absolutely sure, Mr. Allen?
Because I don't drink alcohol.
What do you mean you don't drink alcohol?
Stay away from anything that's gonna get me in trouble. I'm just trying to fix everything, you know. I'm just trying to get back in order, you know.
When's the last time you drank?
Probably like 2 years ago. Maybe somewhere right there.
Well, that can't be true.
Probably like. Well, I just haven't been drinking, you know. I haven't drank anymore.
In this part, the judge questions the defendant about alcohol use. The man gives inconsistent and confusing answers, first saying he doesn't drink, then saying maybe 2 years ago, then 12 months ago, and even mentions mouthwash. The judge becomes suspicious because the answers are not clear or honest. This clip builds tension and shows how important it is to be truthful in court as the judge starts doubting the defendant's credibility.
All right, I'm going to try this again. When was the last time you had something to drink?
Something to drink this morning. Coffee.
Any alcohol.
Oh, that's funny.
Okay, probably like 12 months ago, maybe, somewhat. Can't remember, but 12 months ago, let's say.
So you haven't consumed any alcohol for the last 12 months?
No. Probably mouthwash, something that,
Council approach. Okay, so here's what I'm going to do. Sir, I need straight answers to my questions. So I'm going to give council an opportunity to talk to you about how you address the court and answer the court's questions. So, Mr. Allen, if you could have him have a seat over here, and Ms. Parody will get to you as soon as possible, and we'll see where we go from here.
So I did have a chance to speak to my client. We did speak about the answers to your questions and how it's important to give straight answers. I think he's quite nervous, and I think that impacts his demeanor here today. But again, I emphasize that the court wants straight answers. Regarding his drinking, he does think that he's going to pass. He indicated he has not used any drugs, marijuana, or alcohol. He believes that the last time he drank was around the time of this offense, and hasn't used anything since.
Is that right?
yes,
You send him over. He's going to be put on a scram unit. I also want. You haven't used any drugs? ETG, and I want a urine test also. So he's gonna. So when he goes over, I want a one-time drug test, and then if he's positive for anything, it's going to continue weekly, and then also an ETG, and he's going to be placed on a scram tether.
Would you like him to come back after his test, or?
No,
Okay,
we'll catch up to him.
all right.
Thank you.
Thank you.
Fine to continue at this time.
Thank you.
Here, the defense lawyer steps in and explains that the defendant is just very nervous, which is affecting how he answers questions. She confirms that he claims he hasn't used alcohol or drugs since the offense. Despite this, the judge orders strict testing, including a urine test and alcohol testing, and places him on a scram tether for monitoring. This clip shows the court taking extra precautions due to earlier confusion and possible dishonesty.
Sir, can you please raise your right hand?
Yes,
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
yes, Your Honor.
All right. State your name again, please.
Ewan Williams.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of retail fraud under the Pittsfield Township Ordinance. That's a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. Do you understand that?
Yes,
Understanding all of that, you still wish to plead guilty?
yes,
And to that charge, how do you plead?
guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes,
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak to you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
yes, Your Honor.
In the final clip, another defendant tries to plead guilty to retail fraud, shoplifting. He admits leaving Walmart without paying, but then says he forgot to scan items while doing an Instacart order. The judge stops the plea because the explanation suggests it may not have been intentional theft. Since intent is required for crime, the judge refuses to accept the guilty plea and sets the case for trial instead. This moment shows how even admitting guilt isn't enough if the legal elements of the crime aren't clearly proven.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
I am on probation.
All right. Were you on probation in April of this year?
Yes, Your Honor.
All right. I do have to advise you that your entry of a plea in this case could be a violation of that probation. If it is considered a violation of that probation, that the other court could sentence you to the maximum allowable under the other charge. You understand that?
Yes, Your Honor.
Understanding that, you still wish to plead to this charge?
Yes, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily and of your own free will,
Yes, Your Honor.
and because you believe that you are guilty of this offense?
Yes, Your Honor.
April 1st, 2024, at the location of 7,000 East Michigan Avenue in Washtenaw County, or in Pittsfield Township, Washtenaw County, State of Michigan. What did you do at the Walmart that makes you think that you're guilty?
I left the premises with belongings that wasn't paid for.
Okay. You just got items from Walmart and tried to walk out, or what'd you do?
I forgot to scan some things, but since I left the premises, it's considered taken or stealing from the store's location at the time of being at that location.
What do you mean you forgot to scan some items? Did you know
So-
or not know that you didn't scan them?
So I was on a Zoom call for probation. I was actually in probation class, and I was doing an Instacart order as a mobile delivery, and I just didn't realize I didn't scan a few orders that was on my shopping list. And
All right, let me stop you there. I can't take his plea. He didn't. I don't think he has the requisite intent by what he's saying.
Yes, I do understand. Yes, I do understand. I was just going over the story. I'm sorry. Yes, I understand.
Well, I can't accept your plea given what you told me. What do you want this set for next?
Your Honor, I would ask to set this for final settlement conference.
Jury final settlement conference will be set for October 18th, 2024, 9 a.m. Jury selection, if necessary, will be set October 21st, 2024 at 8:30. Both of those proceedings are in person. Bond proceeding. Thank you.